Thank you very much. Thank you
I
very
recognize
much.
the gentleman from Texas.
Thank the chairman. Mr. Smith, how many members of Congress or the Senate did you subpoena phone toll records?
As I sit here right now, I do not recall a specific number.
Is this the complete list right here? Well, let me ask you this. Am I on this list? Did you target my records and subpoena my phone toll records?
All right, you just watched that clip. Let that sink in for a second. A sitting member of Congress, Chip Roy, finding out years later that his private phone records were subpoenaed by a special prosecutor. No warning, no transparency, no accountability. And somehow we're supposed to just shrug and say, yeah, that's normal. This is exactly why so many Americans have lost trust in Washington.
My understanding is your records were subpoenaed by prosecutors before I became special counsel.
Well, staff would put this up on the screen. I'm thankful for the great staff who discovered the email where I learned for the first time a few weeks ago that my phone records were indeed targeted. We called AT&T and we've learned that they were given to the Department of Justice, as this email indicates, because I had been in communication with Scott Perry, one of my colleagues here in Congress, who literally had his phone taken from him in front of his family. And of course, as we've already talked about in this document, it talks about you could be in violation of the privilege by even obtaining and possessing this information if the member objected to the disclosure. This happened 4 years ago in May of 2022, and I couldn't object because I didn't know. I didn't know until about 3 weeks ago. My question here is, was there any limits to your investigation or the investigation that preceded you, Mr. Smith? Because as egregious as a violation of separation of powers this is, as an egregious and abuse of power it is, it's far more concerning you are clearly targeting American citizens for merely being conservative or supporting the president. We've got memos that we've already been talking about in this hearing from April 2022 that preceded you that establish and open the investigations, one of which has Attorney General Merrick Garland's signature on it. And the focus was the electors. Now that was 6 months before you were appointed. You testified earlier, you met and interviewed Merrick Garland and Deputy AG Lisa Monaco. And you briefed the AG and deputy multiple times. Did you brief them on the electors and the prosecution of their supposed crimes?
I'm sorry.
Did you brief them on the electors and their supposed crimes?
I don't recall specific conversations, but I'm sure that in the course of briefing them, I discussed.
Wasn't that the purpose of the entire investigation as it was set out? Because putting aside that in 1960, as we already talked about, my friend Mr. Tiffany, that Hawaii put forward an alternate slate of electors, the investigation pivoted to President Trump and frankly anybody who knew him. Do you know who Cleta Mitchell is?
Yes, I do.
She's an election lawyer that was involved in filing an election contest on behalf of President Trump in Georgia in December of 2020. A 64-page complaint with over 1,100 pages of exhibits, witness affidavits, and expert witness reports documenting thousands of votes cast in violation of Georgia law, but which were nevertheless included in the vote totals. Now, notwithstanding the disposition of the cases that was filed, is that a criminal act? Filing an election contest on behalf of a candidate for office, a client. Is that a criminal act, yes or no?
No, in fact, we
So
stated.
why did you deem it appropriate to monitor Cleta Mitchell's long-distance phone records in 2023, 2.5 years after the election contest was filed and after the presidential electors were certified? What about Jenna Ellis? What about Sidney Powell? What about Bill Sepien? What crime did you suspect had been committed by them that would warrant monitoring their phone records 2.5 years after the 2020 election was certified?
With respect to Sidney Powell, she is one of the co-conspirators alleged in the indictment. I don't know what you mean by monitoring, sir, if you're talking.
Well, there were some 400 plus Republican conservative groups and leaders who were targeted by your investigation. Their financial records were obtained, records of the RNC, the Trump campaign, Cleta Mitchell, the Conservative Partnership Institute, the America First Policy Institute, NRCC, NRSC, PACs, conservative groups, people all across the country, citizens, because we hear a lot about members of Congress. And we should, because of separation of powers and the egregious abuse of power. But what we're not talking about enough, in my opinion, are the American citizens that have been targeted. Because frankly, are there any limits to the power of a special prosecutor or special counsel? So much so in your abuse of power that in the summer of 2024, the indictment involving classified documents was dismissed after determining your appointment violated the Appointments Clause of the Constitution, but you continued to sign your name on court filings until the time you resigned from office in January of 2025. A federal judge just recently stated a prosecutor who continues to sign his name in court filings after a disqualification order should face disciplinary action or disbarment. I yield back.
Gentleman yields back.
Did the gentleman have the opportunity to respond?
If the gentleman wants to respond, he can.
With respect to the last point, Judge Cannon's order specifically limited her finding to that proceeding. So there would be nothing improper about continuing to litigate the cases in Washington, D.C. And with respect to Florida, there was nothing improper about taking an appeal of that very decision.
What Chip Roy did in that hearing was necessary. He didn't yell. He didn't grandstand. He asked the questions that any serious defender of the Constitution should be asking. Why are members of a co-equal branch of government being surveilled without their knowledge? Where's the line? And who decides when that line gets crossed? Jack Smith wants everyone to believe this was all routine, all lawful, all perfectly fine. But here's the problem. Lawful does not always mean legitimate. And trust us is not a constitutional argument. When you start subpoenaing phone records of lawmakers, conservative leaders, and Republican-aligned groups years after an election has ended, you are no longer just investigating crime. You're setting precedent, a dangerous one. This goes directly to separation of powers. Congress is not subordinate to a special prosecutor. The executive branch does not get unlimited reach just because it slaps the word investigation on it. Our system was designed with friction on purpose to stop exactly this kind of unchecked authority. And let's be honest, if the political labels were reversed, if a Republican prosecutor had quietly pulled phone records from dozens of Democrats, the media would be calling authoritarianism 24/7. Chip Roy is right to question why there appear to be no real limits on special prosecutors. A federal judge already warned that prosecutors who continue acting after disqualification could face discipline. That should alarm everyone, regardless of party. Power without limits always ends the same way. This isn't about defending any single politician. This is about defending the rules that protect all Americans. Once government normalizes surveillance of political opponents, it never stays confined to one side. And that's why we talk about this here. Welcome to Freedom's Voice, the channel where we cut through the noise, call out government overreach, and defend the Constitution without apology. If you believe accountability should apply to everyone, hit that subscribe button, like this video so more people see it, and drop a comment below. Do you think special prosecutors have too much unchecked power, or is this just the cost of trust in the system? Because the moment we stop asking questions like Chip Roy did, is the moment we stop being free.